Hi, everybody. Can everybody hear me okay? Yes. Good. We're off to a good start. Just to tell you a little bit more about me, I'm a Simsbury resident. I've lived here for 17 years, and our firm practices only in the areas of estate planning, probate. It was mentioned I'm a certified elder law attorney. That means I work with seniors and help them to plan with their estate plan and also asset protection planning. Meaning I help them to preserve assets in the event that long-term care unfolds. How can you insulate what you have? So that's the nature of our practice. We do have an office in Simsbury right in Hot Meadow Street. So what I'm going to talk to you about today is the probate process. And let me just start by asking a question. If you want to grab one of those, I got it for you. There you go.
Thank you.
Let me just start by asking a question. What percentage of estates do you think nationwide occur where people die without a will? Let me word it differently. What percentage of people pass away without a will? 33%?
I think it's higher than that. I think it's
50%? It's actually 75%. 75%. So nationwide, 75% of estates, when somebody passes away, are intestate. When somebody dies intestate, that means they die without a will. That's the whole purpose of having a will, is to avoid the laws of intestacy. And some very famous people have died without wills. Picasso, Abraham Lincoln, Howard Hughes, and that was litigated for about 15 years. And most recently, Prince. You don't want to be in that situation because I'll tell you what will happen if you die without a will. The laws of intestacy go into effect, and that means that the state determines where your assets go. And I'll give you my situation. I'm married and I have kids. So if I were to die without a will, what would happen is the first $100,000 of my estate would pass to my wife. Then she would get everything. She would get half of everything else, and my kids would get the other half. I love my kids, but they're 12 and 17 first of all. And second of all, I want everything to go to my wife. So you can see a really basic scenario, married with kids, very basic fact pattern. The laws of intestacy do not meet what my objectives are, which are for everything to pass to my wife. This is why you need a will, a last will and testament. That's my 2 cents. I think everybody should have one. So let's talk about what a will controls, and that leads us into the discussion about probate. So a will controls assets that you have titled in your name alone when you pass away. So solely held, solely titled assets. So my property at 3 Red Oak Court in Weetag, if I die and that's in my name alone, my will has to be filed with the probate court in order for the house to be transferred to my wife. I don't own it alone. Now, it's actually in my wife's trust, but let's say we owned it jointly. And if you're married, you probably have real estate title jointly with your spouse. And the deed would say that you own the property as joint tenants with rights of survivorship. What that means is when you pass away, the property passes automatically to your spouse. And the same thing with bank accounts. If you have joint bank accounts, those accounts will pass automatically. If you have a joint brokerage account, it might say on the statement, JTWROS, joint tenants with rights to survivorship. So that means when the first person dies, it passes automatically to the survivor. Other assets that do not pass through probate, life insurance policies, because you have beneficiary nations on them. The exception would be if you have your estate listed as the beneficiary. Or you have a primary but not an alternate, and the primary beneficiary dies before you. Then what would happen is the default is it goes into your estate, meaning it goes through probate, which is really what you want to avoid. So when I sit down and meet with clients and I go through their estate plan and I go through a questionnaire that I ask them to complete, I go through their life insurance policies, their retirement accounts, their annuities, and I asked them, who's the primary beneficiary? Oh, we are for each other. Who are the alternate beneficiaries? Crickets. And most people don't know. So that's something to be you should be attuned to. Take a look at who your beneficiaries are on retirement accounts, life insurance policies, annuities. Make sure you have a primary and an alternate. These are accounts that would avoid probate. And that's really the objective at the end of the day, is to avoid having your estate probated to the maximum extent possible. So now you know what assets would go through probate. So let's go through that process, what's involved. If you don't have a will, what happens is the probate court will appoint somebody who is referred to as the administrator. The administrator is somebody who's vested with the authority to marshal the assets, file an inventory, and eventually distribute the assets to the beneficiaries, who are, as you know now, the intestate beneficiaries, the intestate heirs, and they might not be who you would want to inherit it. So in my case, it would have been my wife and my kids, when I want everything to go to my wife. The administrator has to jump through a lot more hoops. The administrator, if that person's going to sell real estate, for instance, they have to get probate court approval before doing that. As opposed to a will. If you have a will and you pass away, by the way, you don't file the will ahead of time. A lot of people think you do. The probate court doesn't want it until you're dead. So you hang on to the will. Don't lose it. You only ever have one last will and testament. That's your last will and testament. And I'm guessing, I'm not going to ask, but I'm guessing some people have more than one original will at home. If you do, tear up the old will. And the reason why is your wills might differ. They might say different things. There's been litigation involved in this, where one will says everything's going to my 3 kids, and the other will says everything's going to my 2 kids. And disinherited son finds will number 1 and will number 2. Which will does he take to the probate court? Well, nobody else knows, right? I'm going to take will number 1, where I get everything, and I'm not disinherited like I am in will number 2. So you only ever have one last will and testament. So that will, the executor's job is to file that will within 30 days of the date of death. That's a Connecticut law. Actually, anybody who's in possession of the will has to file it within 30 days. Then there's an executor. The executor is the person who you've elected, you've chosen to oversee the estate. So that person, instead of being the administrator and the probate court judge deciding who's going to administer the estate, you get to choose. You get to elect that person. That person's called the executor. So the executor's job is the first order of business is to file an inventory. And by the way, you should always have an alternate executor, at least one. Because the person you name in the first position might predecease you, might be unable to serve as executor. As an elder law attorney, I see this a lot. Or one spouse might lack capacity, might not be able to carry out the functions of what they need to do as executor. Or what happens most often is the person that you first named just doesn't want to do it. Just because you're named doesn't mean you have to step in that role. You can decline. You can sign what's called a declination. Well, if you do that, then we've got to look for the next person. So you always want to name at least one alternate executor. So the executor has to file an inventory within 2 months of their appointment. The inventory will list all of the assets that are solely owned. The solely owned assets of the decedent. And the executor will have to identify what the date of death value is. So the assets that don't go on the inventory would be joint accounts, accounts with beneficiary designations unless the estate is the beneficiary. So anything that's solely held. I didn't mention it before, but I'm informal, so if you want to ask questions, go ahead and interrupt me.
How about trusts?
It's a good question. Trusts do not go through probate. So,
Regardless of whether they're a family trust or a survivor's trust?
well, let me just break down what it, for people who don't understand. There are 2 types of trusts. There's a living trust and a testamentary trust. A testamentary trust is a trust within a will. So you're referring to, I think, a living trust. There are two types of living trusts, a revocable and irrevocable. In either case, you have a separate entity, this trust, presumably owning assets. When I say owning assets, what I mean is let's just say it's a revocable trust. Most people who have revocable trusts have that in place for the purpose of avoiding probate. So I've got a revocable living trust. And my trust says during my lifetime, all the assets that are in the trust are available to me, to my wife, to my kids. When I pass away, that revocable living trust becomes irrevocable. Makes sense, right? I'm dead, I can't revoke it. So it's a separate entity at that point. It's not a deceased person. We don't have a deceased person's assets. We have this separate entity, which means the probate court does not have jurisdiction. The probate court only has jurisdiction over deceased person's assets. So if the trust is what's called funded, meaning it has assets in it, then the answer to your very long answer to your question is you'll avoid probate with that funded revocable living trust because it serves as a will substitute. When you pass away, the trustee is the person who has legal title over the assets in the trust. The trustee's job is to make a distribution to the beneficiaries. Yeah.
How detailed your will should be? How detailed? Should you describe what in your will? Should it be very detailed as to what paintings you want to go to somebody, what household goods you want to go to somebody? Shouldn't be. I mean, I just know how much detail the will should contain.
Okay, it's a good question. Thank you for asking it for people who didn't hear it. The question is about what level of detail should you include in your last will and testament? Do you have to itemize everything? Mm-hmm. And the answer is no. Typically, people don't do that. Typically, what a will say, there's usually two provisions in a will. One will say, my tangible personal effects get distributed as follows. And mine says everything to my wife, otherwise my kids, but I might leave a memorandum. I might leave something where I indicate what items pass to which members of my family. The will then says the rest, residue, and remainder, it's a term of law, which means everything that the decedent had titled in their name gets distributed as follows. And we fill in the blank. So you don't need to itemize everything. You say everything that I own, the rest, residue, and remainder of my estate gets distributed in the following manner. What some people do list different items. If you're going to do that, you want to be mindful of the fact that the item might change. And what I mean by that is, I wouldn't say that I'm going to leave my property at 3 Red Oak Court, Weetag, to my kids. I would say any property that comprises my principal residence. Or, if you're leaving a car, I have a 1970 Corvette. It's actually my wife's. She was an only child, so she got it from my in-laws. Maybe my son wants it, or my daughter wants it at some point. If I said my 1970 Corvette goes to my son Nathan, but I die with a 2015 Corvette, he doesn't get the Corvette. So that's what I mean about the bequests. If you do have an item you want to go to somebody, like real estate or a car, and your intention is whatever real estate or car you own, you've got to think about that or work with the attorney to make sure it's worded the right way.
Thank you.
A lot to digest, right? So going back to the administration, the executor's job is to file that will within 2 months of their appointment. And then what happens is the probate court is going to publish a notice in the newspaper. And if you read the legal part of the local newspaper, I don't think people normally do, you might see something that says, Mr. Jones died, and if you are a creditor, you file a claim with, and normally list the attorney's name who's representing the estate. So Brendan Daly at 15 Mysterio Drive in Berlin. And so I get notices at that point from creditors, and creditors have 5 months to present claims. So that's one reason why probate takes a long time. You're waiting out a statutory period, meaning the executor can't move on and go to the next step without first making sure that all the creditors are heard from. The executor then, once those claims, he or she receives those claims, the executor's job is to determine which claims are accepted and which are rejected. Let's just say all the claims are accepted. We're going to pay all the claims. There's an ambulance bill and a hospital bill, some credit card bills, and the executor says, I'm going to pay all of these bills. The executor then files what's called a return of claims, a document that gets filed with the probate court listing all of the claims and saying, Your Honor, here are all the claims that are going to be paid by the estate. The next step is to file what's called a Connecticut estate tax return. With my mask, it might be tough to hear. It's not state, it's estate, E-S-T-A-T-E, a Connecticut estate tax return. This is what gives Connecticut a bad rap, because people will avoid probate but still be stuck paying a probate court fee. And let me go through with you how that works. So an estate tax is a death tax. There's a federal estate tax and a Connecticut estate tax. And then there's an amount of money that you can leave to people tax-free. Anything passing to your spouse is going to be tax-free. And anything passing to your spouse is going to be tax-free. There's no estate tax passing from one spouse to the other, assets passing from one spouse to the other. For assets passing to children or to other non-spouse beneficiaries, there's an exemption, a lifetime amount that you can leave by either gifting or, let's say you haven't made gifts, when you pass away, leaving assets. On the federal side, it's $11.7 million. So it's not a bad problem to have, but not many people have it. Not many people that I see have it. On the Connecticut side, it's $7.1 million. So the federal exemption, how much you can leave free of any federal estate tax is $11.7 million, and Connecticut at $7.1. Connecticut's exemption is slated to go up to $9.1 million in January. So if there's an estate tax, you pay the tax to the Department of Revenue Services, to the IRS. Most people aren't paying, most estates aren't paying an estate tax. But you still have to file in all cases, whether you have probate or not. There's a requirement that Connecticut law that you have to file an estate tax return, even if there's no estate tax due, and that return gets filed with the probate court. And the probate court is going to charge a fee based on the size of the estate. And this is how probate courts are essentially 90% of the funding comes from these probate court fees that are assessed by the judge taking a look at the estate tax return and then determining what the statutory fee is. And then the judge says, okay, there's no estate tax due, and stamps it. No estate tax due. And you think, okay, why do I have to go through all this, especially if I don't have probate involved? The reason why, number one, is Connecticut law. Number two, if you own real estate, or you have an interest in real estate, or your trust owns real estate, you have to go through this process, because if you don't, you have a clouded title. You wouldn't be able to sell the property. So the state has what's called an inchoate, an invisible lien on real estate whenever anybody passes away. Whether, again, that's a solely owned asset, if it's jointly owned with a spouse, same thing. Mr. Jones dies, Mrs. Jones is now on the deed, the property transferred automatically to her. She wants to sell it, she can't without filing the estate tax return with the probate court. There's no probate, everything passed automatically to her. She still has to file that estate tax return to clear the title. Because you'll be at the closing table otherwise, and it's not going to go anywhere. Well, where's our estate tax release? You have to get what's called a certificate of no tax, a document from the probate court saying there's no estate tax due. You only get that document from the probate court after you pay the fee. And this fee, everyone's going to ask, it's less than 0.5%, typically, on average about 0.4%. Not a huge number normally. but you have to pay the fee to the probate court for the judge to say, okay, well, yeah, you have this $300,000 property, and it's less than $7.1 million, and your spouse had half of an interest in it as $150,000, or still a probate court fee you have to pay me. Then you get that certificate of release, and you clear the title. Yes?
If the executor rejects a claim by, say, a vendor, what recourse does the vendor have? Do they go to probate, or do they go to civil court to address their grievance there?
You said a vendor?
Let's say it's a vendor, somebody that putting in a claim.
Okay. So if somebody's filing a claim, you have to go through that process when you see that notice, or if you know the person died and you're a creditor, you can file a claim directly with the executor. You don't have to wait for that notice. And then if the executor doesn't pay you, you ask for a hearing at the probate court. And that's the good thing about probate in Connecticut. We have a lot of different courts, and 117, I believe. And they're very user-friendly. The clerks are very helpful. And the good thing is there's a lot of accessibility. So if you're a creditor, you can write to the court and say, the executor hasn't paid me, I want to have a hearing on it. So you don't have to sue, you don't have to go into superior court. Your way to redress that your way for redress would be to file for a hearing in the probate court.
Absent seeing the paper, how does the creditor know who the executor is?
Because the question, if you didn't hear it, how does the executor know who the creditor is? Or how does the creditor know who the executor is? The name will be listed in the notice in the newspaper.
But if they don't see the notice in the newspaper, they're just out of luck?
If they don't see a notice in the newspaper, they're out of luck, yeah. If they don't know that the person passed away, and you get through that claims period.
But they know the person passed away, they just didn't see the notice. How do they find out the identity of the executor?
I'm sorry, I missed the first.
If they know the person passed away.
Yep.
They don't see it in the paper. They
Yep.
go to probate to find out the name of the executor?
Yeah, you call, yes. So if you know somebody passed away, you haven't seen the notice, you're a creditor owed some money, you contact the probate court, it's a matter of public record. And you say, okay, please tell me, for John Smith, who's the executor? And they'll give you the executor and the contact information. Yes?
I have a question, please. So let's say if I owe the house with my husband and I owe condominium with my husband and I die, right? Should my husband just file that estate tax return form regardless of anything else? Regardless of probate, regardless of trust, regardless of anything? Right?
Yes. Yeah.
Am I right?
Yes. So
Thank you.
the question is, married couple, they own the property jointly. One spouse dies, you file this estate tax return. You don't have to file anything else. You file the estate tax return with the probate court, and it doesn't take very long, a couple of months for the court to process it. If you have a closing scheduled, then it can be expedited. And you pay the probate court fee, and that's all you have to do.
So before any kind of process, that's what spouse should do, right? If they own real estate together.
When one spouse dies, if they own real estate together, yes, the spouse is going to have to file an estate tax return.
Okay.
Whether they file that estate tax return with the probate court or whether they file it with the Department of Revenue Services depends on the size of the estate.
I see.
If it's over $7.1 million, they got to file it with the Department of Revenue Services.
Thank you.
Yes?
What about property that's held outside of the state of Connecticut?
It's a very good question. So if you have property located in another state, what will happen is a copy, what's referred to as an exemplified copy of your will, meaning the probate court stamps it as an official copy of the will. So let me back up. If you die a resident of Connecticut, the will gets filed with the probate court in Connecticut. The original, remember, the last will and testament, the only one you have. The probate court will then, if you have property in another state, give the executor an exemplified copy, and that exemplified copy is taken to the probate court in that other state. So you have property in Rhode Island. You're going to have to go through full probate in both Connecticut and in Rhode Island.
And is that true even if it's held in an LLC?
It depends. It depends on how it's held in an LLC. If you have real estate owned in an LLC titled in another state, it's considered personal property. You're still going to have probate. Whether you have probate in Connecticut or Rhode Island depends on the LLC and how it's worded. A lot of people have rental property and they have it in an LLC for liability purposes, a limited liability company, which makes a lot of sense. But it's still a probate asset. So technically an LLC is just an interest in personal property. If it's more than $40,000 in Connecticut, you still have full probate. And full probate means you go through all the processes that I just mentioned, filing the inventory, the return of claims, the estate tax return I didn't get to yet, the accounting. If you have assets in the decedent's name that are at the level of $40,000 or below, you have a short form procedure, meaning you don't have to go through the full probate administration process. It's what's called an affidavit in lieu of administration. You file an affidavit with the court instead of having to go through the full administration process. And it's a streamlined procedure. So you've got a car and you've got a small bank account, and they total $35,000. You don't have to go through the whole process, filing the claims and the accounting. You can go through the short form estate. As to the car, just a tip. On the back of the registration to your car, you can name a beneficiary. And I tell this to all my clients. In every consult I have, every consultation, I ask how the car is titled. If the spouse is a car is owned in one spouse's name, I tell them, make sure you take that on the back of the registration, name your spouse as a beneficiary. My 1970 Corvette, by the way, is my wife's name. So the first thing we did when we got it registered, I made sure my name's on the back of the registration as the beneficiary. And you can avoid probate that way. Because people don't think about it, but you got a car lingering out there, and you're going to have to go through this process, this affidavit with the probate court. Yeah.
If let's say somebody dies, let's say I die or my husband dies, and they don't know what to do immediately, because a lot of times people really don't know where to go and what to do. Can we come to you for services? Would you provide services like this for a fee or whatever? What to do and what steps to take?
In full disclosure, we don't know each other, so but yeah, you can come to me or somebody like me.
Right, that's
Yeah,
what I'm
yeah.
sorry, that's what I meant.
Yeah.
Let's say to your forum, never mind.
Yeah, you should. It's advisable to get counsel, to talk to somebody. I meet with clients where sometimes they know exactly what they're doing. It's very straightforward, and I'll walk them through what they need to do with the probate court.
Just a question I asked, because if you provide this kind of services, I mean, you meaning your firm, if I direct my husband and say, go to this firm, they will direct you or guide you what they have to do.
Yeah, most of the time we will represent the executor
To make sure
and actually do everything.
Okay, thank you.
Yeah, but otherwise you can always go to the probate court and talk to the clerk and see if they can walk you through it.
Okay, thank you.
Yes.
My daughter's name is on my car, on the title, along with mine. So if I die, does half of it go to probate?
It depends on how it's titled. Is it or? If it says
It's and, I think.
okay, so it should be. There's a technicality in Connecticut with how it's titled. In a lot of cases, even if it's and, you can still re-register it in the surviving owner's name. But to be on the safe side, what you want to do is just on the back side of the registration, just name your daughter as the beneficiary to make certain that the car is going to pass to her that way.
Yeah.
By the way, if you have a living trust, don't name the living trust as the beneficiary of your car. I had a client do that once, and I was a trustee, and after spending 3 hours at DMV, nobody could figure it out. They finally said, can we just issue the title to you individually instead of you as trustee? I said, yes, please. And I just transferred the car to the trust. So don't do that. Don't name your trust as the beneficiary of your car. I rarely will recommend that people retitle their cars in a living trust, only if people have exotic cars and very, very valuable antiques. So the next step in the probate court process is filing what's called a financial report. Yes, sir?
Yeah, I got a question. What about if it says and or? using both. And-
Yeah, then it's going to pass automatically to the survivor. If the car is titled and/or,
Yeah,
it will pass automatically to the surviving owner.
okay.
Yes?
So in that case, if everything's owned with Ann, then you don't have to put the beneficiary because it's automatically Ann to the other person.
I'm sorry, I didn't hear.
If it's listed that way, you don't have to fill that beneficiary part out because it's automatically.
If you have it titled and/or, yes, it'll automatically pass. So then, going back to the excuse me, the last part in the administration process is filing what's called a financial report. That's the terminology in Connecticut, a financial report. And a financial report is essentially an accounting. And what the report includes will be, it'll include the inventory value. You start with that value. Then the expenses of the administration of the estate are listed as a deduction, and then you have the amount on hand to distribute to the beneficiaries. And the court will normally expedite that, and I should have mentioned this in the beginning. Most courts aren't requiring hearings. Everything's streamlined. And so when you, for instance, file a will, you can have the beneficiaries sign a waiver where they say, okay, we don't need to have a hearing, Your Honor. That way, we don't have to have a formal hearing on the administration and admission of the, not the administration, the admission of the will and the appointment of the executor. The beneficiaries all sign a waiver and say, we're fine with this person being the executor. The alternative is the people don't sign the waivers, and the court will send a notice to all of the beneficiaries saying, if you want to request a hearing, you have to do so by this date, September 30th. If you don't request a hearing on October 1st, we're going to appoint the named executor. So you're in a position where you have to actually be proactive and request a hearing. Otherwise, the court's going to streamline it and appoint the executor. The same thing will often happen with the financial report that gets filed. People will normally, the beneficiaries will sign waivers, and the court would approve of. The court could see something that doesn't look right and ask for a hearing. The executor's fee is enormous, and the judge wants an itemized listing of how that time was spent because it wasn't provided with the financial report, for instance. One example where the court might request a hearing. But normally the hearing is the accounting is going to be approved without the need for a hearing. Yes?
I have another question. Informal probate process may be done if not expected estate to be contested. What does it mean, actually?
I missed the second part.
It could be informal probate process.
Yep.
If you don't expect your estate to be contested.
Yeah, I'm not really sure what that means. Informal process if you don't expect your estate to be contested.
Yes.
There's no informal process if you don't expect your estate to be contested. It's going to go through smoother. The administration of the estate obviously is not going to be delayed because somebody's contesting it. But you still have, if you have more than $40,000 or you have real estate, in either case, you're going to have a full probate estate. From beginning to end, the timing, 7 to 9 months on average is what I see.
I just read this in financial publication on, what is it site? Infidelity side. They say informal probate process could be done if not contested estate that you have. If nobody contests your estate. I don't know what it means. So
I don't know what it means either. The only informal estate would be if it's less than $40,000. Yes, sir.
Good question. Does the executor have to review his or her decisions with the beneficiaries before settling in an estate?
No. The executor,
And just do, and that's it?
the executor's role, responsibility, and ability, the authority that they have, is controlled by what the will says. So if the will says that the executor can sell real estate, can have access to all the assets in the estate and liquidate securities, et cetera, you don't have to get permission or
It's not
keep.
a democracy. We don't get to vote on it.
Correct.
All right, thank you.
So most wills will will not, in most wills, the language won't list all of the authority that the executor has. Most of the time, and this is what we do, our wills will recite what's called the Connecticut Fiduciary Powers Act, a law, a statute, that lists everything from being able to sell real estate to cattle breeding. I mean, it's everything under the sun. That way you don't have a 25-page will where you're listing all of the different powers. That said, a beneficiary can certainly object to what you're doing and ask for a status hearing with the probate court. Because you're selling the property, you have authority to sell the real estate as executor, but the beneficiaries think you're selling it for much less than what the prevailing market is in the area. And they can bring it to the court's attention.
Is there a standard executor's fee, a percentage of assets or anything like that, or is it vary according to how much work they put in?
I'm sorry to keep doing this. It's just tough to hear with the.
Is there a standard executor's fee?
Oh, the fee. There's no standard executor fee, and this is what I wish Connecticut would adopt some kind of standard. It's actually based on a Supreme Court case law decision from 100 years ago. What's reasonable under the circumstances? It's really amorphous. So it's what the judge thinks based on the circumstances, the role, what you're doing, the complexity of the assets, the complexity of what's involved in the estate, the hourly rate will be determined accordingly.
How much time does an executor spend on these things? I know it's wide variance because the size of the assets and the complexity involved, but can you give a rough estimate of a typical average proceeding where how much time, how many hours of work would the executor have to put out?
Oh, the question is how much time does a typical executor have to spend? It depends. I mean, some states, really straightforward. There's just real estate and a small bank account, and they're hiring the attorney and having the attorney do all the work. They're not lifting a finger, basically. Some cases you have 15 different bank accounts, and you're trying to find assets. I have a case like that right now, where somebody died suddenly. She was a hoarder, and we're writing to all the different banks trying to find out what assets she had, and there's a lot of work involved. So it runs the gamut. It depends. So,
And what is this, I'm sorry, new domestic asset protection trust?
domestic asset protection trust.
Domestic asset protection fund.
It's a little outside what we're talking about today, but
Okay.
it's a trust where you can transfer your own assets to it. And in doing so, you can insulate those assets if you're sued. It's a very complicated procedure to go through. This law was passed in January of 2020. I have not had one client yet, and this is all I do, where I thought it was a suitable mechanism for them.
Thank you.
Yes, sir. Yep.
Last question. Accounting of the estate, is that only at the conclusion or is it a monthly statement?
No, the accounting is at the conclusion.
Conclusion.
However, if you have ongoing jurisdiction because, let's say, there's a testamentary trust, you have a trust within the will, then the trustee is going to have to file triennial accountings. The first calendar year you have to file an accounting, and then every 3 years after that.
Okay.
But if it's just a decedent's estate, you're filing an accounting at the end of it.
Okay.
That's the last thing that you do.
Even if you have a living trust, you still have to do that final accounting?
No, you do not have to file the accounting if you have a living trust, because if the living trust is funded, meaning you transferred assets to the trust during your lifetime.
Yes.
The probate court doesn't have jurisdiction because the trust as a separate entity owns the assets, and the document itself is dispositive, meaning the trustee, it says what the trustee to do with the assets to distribute it to the beneficiaries. So the trustee does not have to file an accounting. What I mentioned is the testamentary trust. If there's a trust within the will, then there are accountings that are required.
So there's no accounting. If you have a trust that has everything in it, there's no accounting with the probate court at all as to the amount that's in that trust.
Correct. If you have a funded trust, you have assets in that trust, there's no accountability to the probate court.
Even with the entire estate that is in the living trust, there's no accounting at the probate court?
Not at the probate court.
Oh.
There's a requirement, though, under the new trust laws in Connecticut from last year. You have to file an account with the beneficiaries under the trust. You have to provide them with an informal accounting.
But that's not gonna cost them anything.
Is it what?
That's not gonna cost anything as to the amount of that trust that you're submitting to the probate.
Yeah, it doesn't go through probate at all. There's just a requirement for the trustee to inform the beneficiaries of how the trust was administered. So on that topic of avoiding probate, now you know what's involved, right? In the administration of the estate. What can you do to avoid that? And basically the things that I mentioned at the beginning of the discussion, which is to have assets titled jointly, to make sure you have both primary and contingent beneficiaries and everything that's critical, especially with retirement accounts. I see this a lot where people omit the alternate beneficiary. And if you wind up with, you have a large IRA, you name your spouse, you didn't name alternates, and you've got kids, it's going to go through probate. That's a really bad outcome. Because if you don't have an identifiable beneficiaries, the IRA has to be paid out over a very short period of time, 5 years. And if it's
10 years.
10 years, I thought it was.
well, no. If you don't have identifiable beneficiaries, then it's paid out over a 5-year period. So if you forgot to name your alternate beneficiaries, then it's going to be squeezed out over a 5-year period, and that's a lot of income tax because IRAs are taxable to you during your lifetime, and whatever's left there when you pass away, that's ordinary income to the beneficiaries. The 10-year rule, that changed last year. It used to be that non-spouse beneficiaries could set up what's called an inherited IRA and take distributions over their life expectancy. Now it's 10 years. But it's better than 5 years, right? So that's why you want to make sure you have the primary and contingent beneficiaries.
I have one more question, please. You mentioned it when you talk about all of this. You mentioned that there was change this year, or was change last year. Who keeps track with those changes? Do we have to redo our living wills, including those changes all the time? Who revised your trust or something with those changes that state try to implement?
So the question about the change in the law, if you have documents in place that are valid before the law changed, they're still valid. It doesn't mean that because the law changed, those documents are invalid. Mm-hmm. But maybe you want to have the documents updated to take advantage of some of the.
Question I have. Do we have to have those updates or not?
It depends.
I see.
Yeah, I mean, if a client calls me and says, Brendan, I saw that the trust laws changed last year. Should I update my trust? I'm going to look at it and look at the facts and make that determination. Now you're fine, or yeah, you really need to come in. So titling of assets and avoiding probate, beneficiary designations, and then assets that you can't set up as transfer on death, or you can't set up as joint owner, having a joint ownership on it, you can have a living trust. A lot of people ask me questions about real estate. Can you have a beneficiary in real estate in Connecticut? You can't. Some states you can, not in Connecticut. So you can't attach a beneficiary to the deed of your property. You can put a child on the property with you, but you're making a gift in doing so. If you're transferring an interest in real estate, if you say, okay, well, I'm going to take my house and I'm going to put my son's name on it with me. You've just given your son a 50% interest in your property. That's a gift. And that has consequences to it. Normally not a gift tax. A lot of people think I'm going to have to pay a gift tax. Normally not, because you can give away over your lifetime $11 million without paying a gift tax. But the more concerning issue is long-term care. And if you're giving assets away and then you go to a nursing home and you're looking at Medicaid, that can impact eligibility. So you got to be really careful about doing things like that. With bank accounts, it's not going to have any impact. With brokerage accounts like stock, it will. With real estate, it will as well. So you're going to make sure you're doing this for the right reason. And if your reason is, I want to avoid probate, so I'm going to put my son's name on the deed, there's a better way to do it. And the better way to do it to avoid a gift is having a living trust in most circumstances. Yeah?
In order to minimize spend down on Medicaid, say for a convalescent or a potential convalescent partner, one of the two goes into convalescent home, and they anticipate this. Basically, all your assets are divided in half, and half to oversimplify it, half goes, is considered to be spent down by the institutionalized spouse. But I understand you can also create a will, and does it have to be irrevocable, or an income-producing trust, I should say, produce an income-producing trust, in order to take that portion of the asset out of consideration for Medicaid spend down?
Yeah, we could have a whole hour's discussion about that. The time doesn't permit me to go through that. I'd be happy to come back and talk to you about long-term care and Medicaid, but that's going down a rabbit hole. I mean, really, it would take me a very long time to answer that question. A lot of what you said is not quite accurate, so you might want to do some research. You can go to our website. We have really good resources on there, but I just can't deviate from the topic that much today. So those are the ways to avoid probate, joint ownership, beneficiary designations, trusts. Sometimes probate, what I tell people too, is probate isn't such a bad thing in Connecticut. It's the circumstances that will make probate delayed and expensive. The number one reason why probate becomes expensive, dysfunctional families. Dysfunctional families, the family dynamics. Somebody's being disinherited, or siblings fight for the sake of fighting. Now, I have a different perspective than a lot of estate planning attorneys because we have a litigation department in our firm. Our litigation department focuses just on our practice areas to do a lot of probate court litigation. So I hear all the war stories. Like somebody objecting to the inventory because the food in the refrigerator wasn't listed on the inventory. I kid you not. I was involved in a case where brother and sister, everything's being left equally to the two of them. No issues there, no one's being disinherited, but they hated each other. We had 2 probate court hearings on who's getting the Judy Garland records. They're just fighting tooth and nail, and I'm representing the daughter who's executor and beneficiary. The son's being represented by another attorney. We're trying to talk to our clients, and they don't want to hear it. Then the son's complaining because my fee's being paid by the estate. Well, stop fighting. So that's why probate becomes delayed and expensive when you have dysfunctional relationships. And I always ask these questions at an initial consultation for estate planning. I want to know what the family dynamics are like. Does everybody get along? Sometimes adult children are in the room with parents and they'll say, no, we don't talk to each other. Okay, well, get out of the room first. And then I'm probably not going to recommend a will.
Wow.
I'm going to recommend a revocable living trust to make it more difficult for them to fight. It doesn't make it impossible, but it's much harder if we're removing that forum, the probate court, out of the process. Because what happens with probate in Connecticut is beneficiaries and even heirs, people who are disinherited, are going to find out when somebody has passed away. So if you're disinheriting a child, that disinherited child, when you pass away, is not only going to get a notice from the probate court, but they're going to get a copy of the will. That's a Connecticut law. That disinherited heir gets a copy of the will. Okay, where's my name? Oh, wait a minute, right? And say, okay, well, it says in here I can ask the court for a hearing. I'm going to ask the court for a hearing. I want to know what's going on here. And that disinherited beneficiary can make life miserable for the executor. So when I hear from a client that that's what they want to do, I've talked through this with them, and I'll recommend in most instances a living trust to avoid that scenario. So probate, but let's say you have a very straightforward situation. Everybody's harmonious. The assets aren't complicated. You don't have real estate in another state. Now, say to people, okay, you're fine having a will. There are law firms that are like trust mills. You've probably seen their ads in Hartford Current, free living trust seminar. That business model and ideology is something I disagree with. It's dependent entirely on the circumstances, whether you have a will or a living trust. The circumstances where I recommend a living trust most often are dysfunctional families, real estate in another state to avoid ancillary probate. You know, probate in Connecticut might not be so bad, but in Massachusetts, you want to avoid Massachusetts probate. So let's remove the Massachusetts property from probate. And you can do that by having a living trust. And then married couples with a very sizable estate, and we want to try to mitigate the estate tax. So in cases like that, I'll recommend a living trust. And sometimes very complicated assets. Maybe it's not, so it's not dependent on how much you have, it's the nature of the assets. But then again, the number one driving reason for that recommendation of using a living trust is the family dynamics. But otherwise, I think probate courts run very well in Connecticut. Again, the clerks are very user-friendly, very helpful, and people can often navigate the process on their own. If you're going to see an attorney, please make sure the attorney is well-versed in this area. You know, there used to be a program at Sesame Street when my kids were younger. One of these things doesn't go with the other. So if you see on somebody's shingle, you know, DUIs, personal injury, estates and probate, that doesn't go with the other things. But you want to see, and I'm not pitching for myself, but see an attorney who practices in these areas so that you have somebody competent who's guiding you. Okay. For people who are being bashful, I'll stop talking now and see if anybody has questions. Yeah.
On the dysfunctional families, can you intentionally say, in the will, can you say, I intentionally leave Billy Bob $0, $1 or 0. I intentionally do this, I intentionally do that. Is that a stopgap for that, to stop them, or what?
No. So the question about, you know, do you leave $1 to this disgruntled beneficiary, this disgruntled heir, to try to head it off and to make it difficult for them to challenge anything? It doesn't work. It actually makes it worse.
Okay.
Because now they're getting noticed. They're in the picture, they're in the window, and they're part of the process. So if you're bypassing somebody, I make it very clear in the way I draft the documents that my client is intentionally, knowingly disinheriting this person, not for lack of love or affection, but for reasons known only to them. That's the way I word it. Because I don't want somebody making the argument that, gosh, you know, mom just forgot to tell Brendan about me. She forgot about me. I've had that argument be made. So I've got it in the will that they're being disinherited. If you're leaving different percentages, maybe you have 3 kids and you're leaving a smaller percentage to child number 3, I would make a provision, put language in the will that says that if anybody contests the estate, they don't get their bequest, they don't get their inheritance. It's called a no contest clause. So we can put language in the will stating that if somebody contests the estate, they're not going to receive their inheritance. I'm sure nobody has family dynamics like that, though. Here, right? I certainly hope not. Any other questions from people?
Yeah,
Yes.
the probate fee, you were saying it's 0.4%.
On average, yeah, on average.
What is that on what goes through probate in total?
No, thank you for asking that question. The question about the probate court fee is not what goes through probate. It's on everything.
Okay.
It's on, you have assets in the living trust. You have life insurance. You have an IRA. It's what's called your gross taxable estate.
Okay.
What gets listed on that estate tax return, that's where the probate court fee is assessed.
Okay, but that's the total fee. So if you have disgruntled heirs and all that stuff, and they have to spend a lot of time, they don't charge more for that?
They don't. That's another good question. Yeah, it doesn't matter how much work is involved on the probate court's end. They're getting the same fee.
Right.
So judges like it when there's a revocable living trust involved because they're getting the same probate court fee. They don't have to go through the whole process of administering the estate.
You just said they don't. You just said there isn't any probate fee.
No, there's a probate court fee in both instances. When you have a revocable living trust and when you have assets through the estate, passing through the estate, you still have the same exact probate court fee. You don't have probate involved, the full administration of the estate, when you have assets passing outside of probate. Yes.
I have one more question. If one has life insurance, term life insurance, let's say, and there is a beneficiary when person dies during this term life insurance, right? Can this be spelled differently or assigned different person to benefit from your death in your will? Will it override what you have it or not?
So to the question, you have a life insurance policy and you name a beneficiary and your will says something different.
Yes.
Your will says, I have this life insurance policy with John Hancock.
Yes.
and I'm naming my son as the beneficiary, and the policy itself has the beneficiary named as the daughter, the policy controls. It's basic contract law. So the policy says it goes to the daughter, that preempts, that trumps what's in the will.
So that priority, what you have, okay, thank you, that's
Yep.
important to know.
And that's, you have to be mindful of that and making sure that you don't have a distortion in your estate plan rather. So what I mean by that is you have your will that says everything goes to your 3 kids, but then you have all these bank accounts jointly titled with 1 child. And I know why people do it, for convenience purposes in the event that you're incapacitated. But what's going to happen is you pass away, those joint accounts are going to pass to that daughter. So daughter Jane gets, $300,000, and I point this out during a consultation. The client 10 times out of 10 says, well, that's okay. Jane's going to make sure her siblings get their shares. And that doesn't always happen. And legally, she's going to be, in most instances, entitled to that money. So you got to be mindful of what does your will say, what are your intentions, and making sure everything's flowing to the right people. So you don't want to have accounts titled jointly with adult children. There's a better way to address the incapacity that's having a power of attorney. A different discussion. But there's a different way to do that.
Thank you.
What if there's a valuable collection in the family? How do you handle that?
With a valuable collection? Well, it depends. I mean, you can say in the will that the collection is to be distributed to certain people. You can say in the will that the executor is to sell the collection. If it's an item that or you can reference it, you incorporate it in that memorandum I had referred to, saying, I want that valuable collection to be distributed as follows, and I'm directing my executor to do that. But if you know that people might make an issue about this and might fight over it, put it in the will. I want this valuable, I direct my executor to distribute the valuable collection to the following people. Any other questions, folks? Well, this has been fun. Thank you for having me. And you have my contact information, so feel free, and please take me up on it. If you have questions, email me. That's the best way to reach me. I'd be happy to answer your questions. I can't give you legal advice. Don't say, Brendan, here's my circumstance, what should I do? But I can answer any substantive questions you have.
It was very clear. Thank you so much.
Oh, thank you.
Very clear.
Funding for Simsbury Community Television is provided in part by contributions from viewers like you. Thank you.